International investing, it's a high-stakes game. We're talking strategy, billions of dollars, the whole 9 yards. And for decades, everybody thought they knew the rules. Well, a recent decision from India's Supreme Court just dropped like an earthquake, and it has completely rewritten the entire playbook.
So let me ask you something. How do you make $1 billion on an investment and then pay absolutely zero tax on it? Sounds kind of impossible, right? But for years, this was the central puzzle for huge multinational companies investing in India. And believe me, for a very long time, they had a very elegant and very profitable answer.
That's right, it was totally possible. But the era of what we call form over substance is now officially over. A strategy that literally underpinned billions and billions of dollars in tax-efficient investments has just been taken apart, piece by piece, leaving the entire global investment community scrambling.
So how did this billion-dollar game even work? Well, for years, really savvy investors used a loophole in the tax treaty between India and a tiny island nation, Mauritius. The play was actually pretty simple. You'd set up a holding company in Mauritius to own all your Indian assets. Then, when it was time to sell, the profits would be taxed under Mauritius's super favorable rules, which often meant a tax rate of 0 instead of in India.
Okay, and that brings us to the one case that changed absolutely everything. We're talking about a multi-billion-dollar deal involving some of the biggest names you can imagine in tech and finance. The US-based investor, Tiger Global, the Indian e-commerce giant Flipkart, and the buyer, of course, was Walmart.
So here's how the whole thing was structured. At the very top, you've got the US parent company, Tiger Global Management. They owned a huge stake in the Indian company, Flipkart. But, and this is the key, they didn't hold it directly. Nope, they held it through a couple of companies based in Mauritius. So when Walmart came along and bought Flipkart back in 2018, Tiger Global sold its shares through those Mauritius companies and then claimed tax exemption under that India-Mauritius treaty.
And this, right here, is where the fight began. The Indian tax authorities took one look at this and said, whoa, wait a minute. This company in Mauritius, it has no real business, no employees, no independent mind of its own. It's just a see-through conduit, a paper-thin shell company. But Tiger Global, they argued it was all perfectly legal, and they waived their official Tax Residency Certificate, or TRC, from Mauritius as proof.
So this whole mess forced the court to ask a really fundamental question. Where was the real control? Where was the actual head and brain of this whole operation? They had to look way past the paper trail to figure out who was really truly calling the shots.
And this image just illustrates the court's approach perfectly. On one side, you have the form in Mauritius. And yes, board meetings were technically held there. Yes, resolutions were signed by local directors. But on the other side, you have the substance in the USA. And what the court found was that all the critical financial decisions, the entire investment strategy, and most importantly, the actual decision to sell, that all came directly from the US parent company.
And here it is, the knockout punch from the court. It ruled that just rubber-stamping decisions that were made somewhere else completely invalidates the whole structure. Basically, if the local directors had no real power to make decisions, then the company couldn't truly be considered a resident of Mauritius for tax purposes. Game over.
And so, that was it. The Supreme Court delivered its final judgment, and it sided decisively with the tax authorities. This was the exact moment the ground shifted for good. And listen to the powerful language the court used here. It gave the tax authorities a crystal-clear green light to pierce the corporate veil, basically to look straight through these paper companies if they don't have any real commercial substance.
Now, this is so critical. The court didn't just find some technical error. No, it called the entire setup an impermissible tax avoidance arrangement. This wasn't just a slap on the wrist. This was a fundamental rejection of the very legitimacy of these kinds of structures.
So, what does this mean for everybody else? This verdict wasn't just about Tiger Global. It instantly put thousands of similar investment structures, worth billions and billions of dollars, directly under the microscope.
You have to understand, for 20 years, ever since a famous judgment called Asadi Bachao Andolan, a tax residency certificate was seen as basically sacred. If you had that one piece of paper from Mauritius, you were safe. It was an iron-clad shield, the absolute cornerstone of nearly all foreign investment planning into India.
But this ruling, it completely shatters that shield. The old way of thinking is gone. Now, a TRC is just your ticket to get into the game. It doesn't guarantee you'll be safe once you're on the field, especially if your whole setup is found to be a sham. Okay, so right about now, you might be thinking, all right, but what about investments made before the rules were formally changed in 2017? Surely those are protected by grandfathering clauses, right? That was a really common belief, sort of a perceived safe harbor. Wrong. The Supreme Court completely rejected that argument. The ruling makes it plain that these principles of anti-avoidance, they apply to the arrangement itself. If a structure is considered a colorable device or a sham designed only to avoid tax, then no grandfathering protection is going to save it. Like the court said, fraud unravels everything.
So, with the old playbook completely torn up, how on earth do investors navigate this new era? Well, the message from the court couldn't be clearer. Substance is king. But what does that actually mean in practice?
Think of this risk matrix as your new map. If you have really high control from a parent company in, say, the US or the UK, and that's combined with very low commercial substance in a place like Mauritius, well, that's the top left box. That's the Tiger Global scenario. It's a super high-risk zone, and you can bet litigation is coming. The goal now is to get to the bottom right, independent local management and high commercial substance.
So what do you do now? Well, 3 things are absolutely essential. First, you've got to conduct a portfolio health check. Investors have to review their structures and ask some really tough questions. Do our local directors have real power? Do we even have a physical office? Second, exit readiness is key. Selling an investment just got a lot more complicated, and buyers are going to be way more cautious. And third, you need a governance mandate. This isn't just a tax issue anymore. It's a board-level governance issue that needs a real commercial reason to exist.
Okay, so let's just boil this all down to the 3 essential takeaways from this entire story. Number 1, substance is king. The real head and brain of the operation has to be in the treaty country, period. Number 2, the TRC is not a shield. It's a necessary ticket, but it offers zero protection for a conduit company. And number 3, grandfathering is not absolute. Sham structures can and will be challenged no matter when they were set up.
At the end of the day, the Supreme Court's decision has armed tax authorities with a powerful new tool to look right through these complex international structures. This case might be closed, but it has swung the door wide open to a whole new level of scrutiny. And the question that every single international investor is now asking is, who's next?